Be ready in 3, 2, 1, start. Lieutenant Counsel appearing for the appellants has placed reliance on the decision of the Lahore High Court. The learned judge held that removal of the time of the absentee co-seer from revenue records at the instance of other co-seers is an overt act amounting to ouster and commences adverse position of the co-seerers in position, the reason being that removal of the name was done openly, and if the absentee co-seerers would have taken an interest in the land, he would not have failed to notice of it in the ordinary course, and hence his knowledge of the adverse claim for other co-seerer may be reasonably presumed. In reply, learned counsel for the respondents has also placed reliance. The learned single judge held that if a property belongs to several co-seerers and one co-seerer is in possession of the entire property, his position cannot be deemed to be adverse to other co-seerers, and he must be deemed to be in possession on behalf of all other co-seerers, and adverse position cannot be founded on the basis of such exclusive position unless there has been ouster of other co-seerers. Regarding mutation in the revenue record, learned judge held that mutation in the name of one co-seerer cannot be any indication of adverse position until it is shown that it was obtained after a clear declaration to the effect that title of other co-seerers was denied. In our view, the correct legal position is that possession of a property belonging to several co-seerers by one co-seerer shall be deemed that the possess the property on behalf of the other co-seerers unless there has been a clear ouster by denying the title of other co-seerers, and mutation in the revenue record in the name of one co-seerer would not amount to ouster unless there is a clear declaration that title of the other co-seerers was denied. After the death of Hira Singh, one collateral Srimati Har Kaur got her name muted and took position, which was questioned by Rupa Singh. Both the parties were litigating, and ultimately the court decided in favor of Rupa Singh, who got possession of the land and his name was mutated in the revenue records. After the death of Rupa Singh, his grandsons also got their names mutated, which was challenged unsuccessfully by the plaintiff. On the facts proved in the case in hand, we are of the view that the appellants have proved that their possession of the land in question is in continuity for more than the statutory period, in publicity and adverse to the Jagjit Singh and his other collateral, and they have perfected their title over the land by adverse possession. We therefore find merit in the present appeal, and accordingly it is allowed by setting aside the impugned judgment, and the judgment of the trial court is restored. Consequently, suit filed by the plaintiff is dismissed. We direct the parties to bear their own costs. Learned counsel for the contesting respondents submits that the assistant registrar was well within his jurisdiction to have registered the list of office bearers, keeping in view the proviso contained in Section 4 of the Societies Registration Act, as amended and applicable in the state of UP. Stop.